Hello and welcome to Reality Check. For a law that has been at the center of a storm sparking nationwide protests, the Citizenship Amendment Act is very skimpy on details. The act is only a few pages long, with little to defend the multiple criticisms leveled against it. But now, in response to multiple petitions in the Supreme Court challenging the CAA, the government has offered its first detailed defense of the act in the form of a 130-page affidavit, an attempt at a point-by-point rebuttal of the main grounds on which the act is being challenged. That the act violates the constitution, that in the garb of protecting minorities from India's Muslim-majority neighbours, it discriminates against Muslims, that it ignores some minorities but recognizes others, and so on. A deep dive into the affidavit, however, throws up multiple contradictions, reversals, and outright bizarre arguments by the centre. We've zoomed in on the most significant. Number one, to the charge that the CAA violates Article 14 of the Constitution, which ensures equality to all in India, the affidavit says that the CAA is benign. It does not arbitrarily discriminate. The reality is this: the Citizenship Amendment Act pertains to illegal migrants. Now, under the Indian law, illegal migrants are not eligible for citizenship. But under the CAA, illegal non-Muslims will get citizenship, but illegal Muslims will not. Hence the charge that is discriminatory. The affidavit addresses the charge that the Act ignores the persecution of minority sects in Pakistan and Afghanistan, sects like Ahmadiyas and Hazaras, but using somewhat of a bizarre defense. The affidavit claims that India, not its neighbors, will define who is a minority in Afghanistan, Pakistan and Bangladesh. The definition of minorities under CAA cannot be dependent on the laws of Afghanistan, Pakistan and Bangladesh. This is the centre's argument. Now, the reality, of course, is that how can India reject the definition of minorities by foreign countries? The centre, by the way, chooses to cite laws of neighbours to defend CAA, to show that neighbouring countries are anti-minority. The CAA cites the constitution of Pakistan, Afghanistan and Bangladesh. So at times it is using the laws of those countries, and at other times it says it won't. We'll use our own definition. The next point, the affidavit also tackles the question of why the CAA doesn't provide protection to minorities facing persecution in India's other neighbouring countries, like the Rohingya Muslims of Myanmar. The centre claims in its affidavit that Rohingyas are economic migrants. It says that the Rohingya migration is related to ethnic and linguistic discrimination, and goes on to say thousands of Rohingyas have come into India mainly through Bangladesh in search of better economic opportunities. Now, as we know, the reality that Rohingyas, according to the International Court of Justice, face the risk of genocide. The ICJ, as recently as this year, asked Myanmar to take steps to prevent genocide of Rohingyas. This was in January 2020. The affidavit also repeatedly makes the point that the Supreme Court cannot rule on CAA, since CAA pertains to India's foreign policy. This is the claim, that the CAA pertains to foreign policy and hence the courts can't interfere. However, CAA, India has repeatedly said, is an internal matter of India. The foreign policy aspect is mentioned 5 times in the affidavit, but Ravish Kumar, spokesperson of the MEA, has time and again said that CAA is an internal matter of India. Let's listen in to one such statement.
This is an internal process. This is a matter internal to India. Number one. Number two, Act just provides expedited consideration for Indian citizenship to persecuted minorities.
So is it a domestic matter or is it a matter of foreign policy? The affidavit also tackles the charge that the CAA violates international laws and conventions, again with a provocative argument. The affidavit claims courts cannot overrule CAA on the basis of international laws. It says if Parliament has said no to a principle of international law, domestic courts, that is courts in India, cannot overrule it. It then goes on to say that a law like CAA is valid even if it is contrary to the Comity of Nations or international law. This raises the question, has the centre accepted that CAA may in fact be a violation of international law? And finally, several of the petitions filed against the CAA have also raised concerns over the National Register of Citizens, NRC, which they argue is a discriminatory exercise. The affidavit by the centre says NRC is a necessary exercise, that sovereign governments have the right to bring in NRC. Now, this appears to contradict the centre's latest position that an NRC is not on the cards, something clarified time and again by the Prime Minister himself while he was on the campaign trail in Delhi.
मेरी सरकार आने के बाद 2014 से आज तक मैं 130 करोड़ देशवासियों को कहना चाहता हूं, कहीं पर भी एनआरसी शब्द पर कोई चर्चा नहीं हुई है, कोई बात नहीं हुई है। सिर्फ सुप्रीम कोर्ट ने जब कहा तो सिर्फ आसाम के लिए करना पड़ा।
All right, so again the question mark, is the NRC not on the table at all, or as the affidavit just filed a few days ago indicating that the centre is very much committed to the NRC. Joining us tonight, Shoaib Danyal, Assistant Editor, Scroll.in, someone who's been tracking the story very closely. Deshratan Nigam, political analyst, supports the RSS, is with us. We'll be bringing you more voices in just a second. Shoaib, just to now look at this affidavit, I mean, there were so many aspects to it which really did sort of make one head spin. I mean, if I had to pick one that really seemed quite extraordinary, was the government's claim that they will define who is a minority in a foreign country, and that this will not be dependent on the legislature or the governments of foreign countries as to who they define as a minority. India will define who gets to be a minority or not in countries like Afghanistan, Pakistan and Bangladesh.
Yeah, you know, Srinivas, this really strikes at the heart, because the BJP has always, the union government has always said that the CAA is about persecution, right? But at the end of the day, its critics have said that it's an arbitrary listing of communities. And this really gets to the heart of that, because at the end of the day, the CAA actually does not look at persecution. You know, it not only makes this point that India will define who is a minority or not, it actually rejects the fact that intra-religious persecution somehow is a lesser form of persecution than inter-religious persecution. Now, we know, yeah, can you hear me?
Yes, go ahead. Can hear you.
Okay. So the thing is, you know, this is it's a fact-free position. I mean, you know, we know from Pakistan that Ahmadiyas there are easily the most oppressed community in Pakistan. So, you know, this really strikes at the heart of this persecution argument. And the other thing where it strikes, of course, is the fact that the Modi government has sort of said that it's not going to include, it's only including Afghanistan, Bangladesh and Pakistan because they are theocratic Muslim countries. Now, on the other hand, you know, this again is a fact-free position about persecution. England is a theocratic Christian country, but that doesn't mean it persecutes its minorities. By international standards, it has a fairly good standard of human rights. Right. On the other hand, we know that countries like Sri Lanka and Burma have you know, terrible records of persecution. Bhutan, by the way, is a theocratic country, but it's not in their list. Right. You know, so it's sort of shot through with contradictions. The other one, you know, that I just wanted to point out, and I'll close, is one of the very interesting things that the CAA says is it doesn't affect the rights of Indian citizens. Now, again, you know, there has been a sort of, you know, there's been a bit of a gaslighting exercise since December, where we all expected to forget that Amit Shah had a chronology that he listed, by which he meant that the CAA will come first and then the NRC will only affect Indian citizens. Right. So we just can't wish that away and, you know, somehow argue now that the CAA is... That link was never made. Okay. That link was never... The Union Home Minister, right? We have to... If that link is going to be broken, the Union Home Minister has to come out on the floor of Parliament and tell us there is no link.
You know, Deshratan Nigam, is this a worry now for the government? Because as I mentioned at the introduction, that so far the bare bones of the act such as we had it was barely 2 pages long. Now we have this 130-page defense put before the court, and in a sense the centre has now revealed its hand. It's given us a sense of what its arguments are going to be like when the hearings actually begin. But as we just pointed out, there are so many fundamental loopholes and contradictions just in this preliminary affidavit itself.
No, certainly not. Let us be very, very clear. This CAA is not based on religion but religious persecution. There is a distinction between the two, and therefore it does not violate Article 14. And let me bring it through example. You talked about Rohingyas. Rohingyas, Rakhine state is adjacent to Bangladesh. And for Bangladesh, it could be a religious issue, but if these immigrants come to India through Bangladesh, then it is not considered as a case of religious persecution. Then under the international law, it is considered as onward movement, not based on religion but for other reasons, which in the affidavit it is said economic reasons. And Rakhine was Rohingyas entire struggle was for the purposes of independent state of Rakhine. And if you recall the history, that it was Britishers offered to Jinnah refused, and
no, I'm saying,
and let me also again bring it one important fact
you're talking
that you're saying.
I just quoted to you that the International Court of Justice, as of January, have said that the Rohingyas face genocide. So where on earth can anyone turn around and make an argument that they're not persecuted? For Bangladesh, it will be religious persecution because under the international law, it is considered the first state, which is the adjoining state. If they move there, then it is the right to have a shelter in Bangladesh. But if they move to India from Bangladesh, then it is considered as an onward movement, can be considered as a ground for immigration or religious persecution. That's a
distinction. That's also an international law.
Right, but the CAA is actually not saying any of that.
Again, let me know.
I'm saying the government's own affidavit
complete my argument.
Is not saying any of that. The CAA is simply dismissing the Rohingyas by saying that they are economic migrants while they've actually fled genocide. So again, I mean, is this kind of hair splitting going to backfire in court?
No. This is argument of law and can be taken at any stage in a court of law, even beyond affidavit.
Okay,
it is not necessary that you put all your legal points in the affidavit.
Okay,
let me finish off. There is a similar.
Oh, I see. Okay, yes.
Go
ahead.
No. Let me just finish off one more sentence.
No, go ahead.
See, there is a similar law called Lautenberg Amendment in USA of 1989, which also selectively gives, citizenship based on religion, which is Jews and Christians from selective countries, and it has been held to be constitutional in the US Supreme Court, topmost court, and it has been there since 1989. Certain amendments have taken place.
I'm aware of the
and there are many countries, and it has been tested against international law. It has been proven at the international level that such kind of a law is constitutionally valid
it's interesting
in terms of their respective constitution and also the international law.
Okay, if I may move on, it's interesting that you actually bring up international law, because as we've just pointed out in the affidavit, India virtually seems to be admitting that the CAA may actually fall foul of international law. So far from claiming that actually CAA is very much within the parameters of international treaties, conventions and laws, the CAA is actually saying that even if the law is contrary to the Comity of Nations or international law, the Supreme Court has no jurisdiction over it. Anyway, Mami Swaroop is joining us, lawyer, Madras High Court. He's someone who's been looking at this particular act and law, and I believe is critical of it. Now, Mami Swaroop, I don't know if you had a chance to go through the affidavit that the centre has filed. Do you find that there are questions? Okay, we'll just try and Mami Swaroop, we'll come to you in just a second. We're just going to try and get your audio in just 1 second. But sure, just to come back to you, to go back to the point that Deshratan Nigam was making, that in a sense now, and we've seen this already, there's a lot of retrofitting of arguments to defend why the Rohingyas have been left out, why the Ahmadiyas do not count as minorities, etc. Now, is that something which you think is going to really stand up in court? Or let me actually show you for a second, let me try to see if we can go back to Mami Swaroop. Yes, Mami Swaroop. Go ahead, Mami Swaroop.
Yeah, so if I were teaching, I mean, this counter and this act, there are serious holes. If I were teaching law to a bunch of first-year students, constitutional law, I'd probably use the CAA as a classic textbook example of a law that violates the twin test of classification. And that's probably the reason why they had to file a 130-page counter to defend a 3-page law, right? To just start off on this counter, their thrust of the argument of the central government seems to be that the CAA is part of the sovereign function of Parliament, and Parliament, they in fact say, you pointed it out in your introduction, they in fact say that they will choose who the minorities are, they will decide who the minorities are, and it doesn't depend on whether these people are actually persecuted in the home countries, whether they're considered minorities in the home countries or not. I'll just give you a very a simple example, which is that we've all spoken about Bangladesh. I mean, we've all spoken about Myanmar and Sri Lanka. But one thing I'll tell you, a simple example here in Tamil Nadu, which I've seen. There is a petition pending in the Madras High Court. A boy who came to India as a Sri Lankan refugee when he was barely an infant. He's finished law in India now. He's lived in India all his life. Right. He can't register at the bar because he's not a citizen of India. These are the people excluded from the CAA. Right. So and the central government's justification for leaving out Sri Lanka is that they have given other benefits to people who have come from Sri Lanka. But that's not the heart of Article 14 is that you have to give the same benefits to all people who are similarly placed. People from Sri Lanka, people from Myanmar, all these people face religious persecution. They come to India on the back of religious persecution. Right. So, and the other argument that the counter does not.
Let me, I know there are lots of points. Let me just try to, because Deshratan Nigam also wants to come in. Deshratan Nigam, I want to ask you one other aspect which has come up in this affidavit, which continues to bedevil us about where the government stands on the NRC. So, as we've heard now, the government appears to have done some sort of a rollback, saying, Prime Minister saying, koi charcha nahi hua NRC pe, who's saying NRC, there's nothing like an NRC on the table. But here in the affidavit, you have very much the government saying that the NRC is on the table. So, is the NRC on the table or off the table?
See, before I come to NRC, I'll give you one example.
Yes.
The sovereign function of the government of India to decide who is a minority or who is not a minority. Because presume a situation where Pakistan decides to, declare somebody as a minority and then try to push those people into India. Right. So would Indian government then, accept them as minority? This is India's sovereign function to decide who's a minority or not, and that function cannot be delegated to anybody.
So if we have no regard, just a second, can I just ask you a question? If we have no regard for Pakistani law or for Bangladeshi or Afghan law on say minorities, then why are we going by their constitutions? That's also a matter of law, is it not?
See, let me tell you again.
How can you cherry pick what law you like and what you don't?
We will respect Pakistan law. No, we will respect Pakistan law as long as it is not contradictory with an Indian law. And therefore, CAA comes into the picture. Once it is a law, and if there is a contradictory law in Pakistan, our law will prevail over that. Let us be very clear on that.
No,
now,
but I don't understand.
Let me about NRC.
Yes.
About NRC.
Okay, sorry, go ahead. Yes, about NRC. Go ahead. Go ahead.
About About NRC, let me tell you, it is inherent and intrinsic part of a constitution. If you read Article 5 to 12, it is very clear that citizenship an issue which has been delegated to Parliament.
That wasn't my question. Deshrata, that wasn't my question.
Build up my point.
Was simply, is it on the table or off the table at the moment?
Let me build up my point.
We have very little time to build up point.
Let me tell you, NRC can never be off the table.
Okay.
NRC can never be off the table because it's the constitutional and statutory responsibility of the Government of India as provided under the Constitution.
Okay, Suhas Chakma joining us, Director Rights and Risk Analysis Group. Suhas, great to have you. Sorry we could only get you in at the last minute, but you know, on this point of the centre's affidavit, perhaps you may have also had a chance to see it. As we've been saying, first detailed defense explanation of the CAA, 130 pages long. But is it doing a convincing enough job in your view?
I don't think centre has any legs to stand on. First of all, they don't understand legal immigrant. Because if they understood who is a legal immigrant, then they won't have raised issue of Baldev Kumar, who is an illegal immigrant at this point of time. So they don't understand the illegal. Second, they don't understand who should be given the, who is a religious persecuted person. Because they don't understand one fact that people who are living the jurisdiction of India, includes the Tamils, includes the Chief, the Tibetans. And when it comes to Article 15 of the Constitution, your foreign policy is not going to determine. Because if your foreign policy is determined, then at that point of time, the Tibetans won't be voting here.
Right.
You have a problem with that issue, but you have to remember, Tibetans are voting across the country. And if you say that, foreign policy issue, so that's why we have underclassified the Tibetans, I don't think that's going to stand in court. You have to remember, Tibetans are getting only right. So, affidavit which has been given by the centre, first questioning the court, second, identifying the legal immigrant, so the illegal immigrant, I think they have no clarity apart from saying that, we want to favor somebody else.
Okay.
We want to identify.
Okay.
Please, if you want to identify,
yes.
You want to help the people already identified.
Right. Okay. Just very quickly in conclusion, Shoaib, because now, as we said, all this is now going to be tested in court, but I wonder if now the government will have a scope to try to reconcile some of these contradictions. As Suhas was saying, one straight off the bat, we still don't know whether they're considering CAA as a foreign policy issue involving other countries or as an internal issue.
I mean, that's it. It just shot through with contradictions. I mean, there's a bit in the affidavit which really, in a way, is a window into the government's thinking here. It again goes back to partition, and it says partition took place on the basis of religion,
right?
And therefore, CAA is based on religion. Now the thing is, I mean, are we going to be stuck on these debates forever and forever and ever and ever?
Yeah.
And basically, this is just politics right now. You're not. Rather than have a humane refugee law, you are using the legitimate plight of people in Bangladesh, Afghanistan and Pakistan to push domestic politics. There's nothing really beyond that, to be honest.
Okay, well, let's see how it actually plays out now that, in a sense, the first cards by the centre are on the table. But thank you all, gentlemen, so much for joining us. That's all the time we have on Reality Check. Thanks for watching. Good night.